Okay, good morning everybody. I'm going to start off this panel with my presentation. So I'm going to talk about the tensions between the attorney-client privilege and the duty to report suspicious activity under international law. So I want you to imagine like a top five, between two very important principles of law, the attorney-client privilege on one hand, and on the other hand, the duty to report suspicious activity related to money laundering by the attorney. So it's going to be very interesting. So let's get started. So just imagine suspicious activity like a money movement going through a bank account, like a regular customer checking account open in Bank of America, whatever. So this rapid movement of money can be suspicious for like a prosecutor perhaps, because that can indicate money laundering, right? So we have money coming into the bank account, and we have money going out from the bank account. So in a rapid way. So you can ask, who is the owner of the funds? So what is the source of the funds? What is the source of the wealth of the person who is making the transaction? So what is the rationale behind the transaction? Is there any contractual relationship, commercial relationship, whatever is the case? And who is the party? So who is the party and where the money is coming from? Is it coming from a tax haven jurisdiction? Is it coming from offshore? Is it coming from, I don't know, whatever is the case? Is a legal entity, is an NGO, or is an individual person, right? Then coming to the bank account, the relationship between the account holder and the sender of the money, and then we got over there the money going out. So where the money is going to? Is it going to an offshore jurisdiction, the tax haven jurisdiction? Is it going to an NGO? Is it going to a religious organization? Is it going to a legal entity or individual? In a rapid way. The money comes in Monday, Wednesday is out, right? So that could be suspicious. What about if we do the same picture? What about if we do the same picture, but with the attorney-client's account? With the attorney-client's account, in the way that IOLTA's account. So what about if the money is coming into the largest client account, the attorney-client's account? And what about if the money is going out? This is very important because we have some rules in many jurisdictions that prohibit the attorney to use the client accounts as a banking facility. So just keep it in mind. So we have a war on money laundering. It's a global war. And guess what? The battlefield of this war is the global financial system and also the local financial system, right? So organized crime is a lucrative business for criminals. Look the data. 3.6% of the global GDP is the profit of organized crime. You have the data over there. And guess what? We have some profited crimes. I think the most common crimes that make profit is drug trafficking. So the drug lords from Colombia, Mexico, Italy perhaps, I don't know. I'm from Colombia, we have that problem, the drug problem. But also we have human trafficking, huge crime. Those drug and human trafficking, those guys use the force to dominate the victim and make the profit. But also we have the white collar criminal. Those guys are very well, dressed up, very well spoken, they speak English, they go to conferences, whatever is the case. So those guys do not use force. They are super smart. And in this area, we have tax evasion, my friend, you are a tax lawyer. We have insider trading. We have market manipulation. We have corruption, market manipulation and insider trading and financial fraud perhaps are the most critical financial crimes in the world. All of this criminal activity create a profit for the criminals, for the criminal organization. Somehow, somewhere, they need to launder that money. And the best way to launder that money coming from insider trading, from foreign corruption, from tax evasion, whatever, is the financial system. The banking institution, the security broker dealer, now the crypto world, the fintech, and also attorneys, right? Okay, perfect. So the battlefield is the global financial system, but you can ask, do we have any gatekeepers who help law enforcement and the rule of law to protect the financial system from criminal abuse? Gatekeepers? The answer is, of course we have it. We have professionals who holds the key either to close the door for the criminals to use the financial system or to open the door for the criminals to pour the money to the banks. And one of the professions that are deemed to be gatekeepers are attorneys, along with accountants, real estate agents, and pretty much attorneys. But we're going to focus on attorneys today. Why the attorney is super attractive to criminals? Why we are like a Tom Cruise for them, or like Julia Roberts for them? We are super attractive for those criminals because these services. So we help the client to incorporate companies, trusts, and NGOs. Also, they can use the client's attorney account to transfer funds through the account, like a banking facility. Also, we can help the clients to purchase and sell of real estate. That's huge. And also, we can assist the client to purchase and sale of companies, merge and acquisitions, all of this stuff. So that's the reason why criminals find us attractive for money laundering purposes, right? Watch this video. 1 second.
Last night, 60 Minutes aired a report using hidden footage that raised questions about how far some American lawyers might be willing to go to help bring questionable funds into the U.S. The story showed what happened when an investigator for Global Witness, a London-based nonprofit organization, went undercover 19 months ago. While posing as the representative of a phony African official, he met with more than a dozen New York law firms to get advice on moving tens of millions of dollars into the United States without the minister's name being revealed. He secretly recorded the conversations. Here is part of Steve Croft's report.
Good to see you. Good to see you.
The undercover investigator, who called himself Ralph Kaiser, told the lawyers that the minister had used his official position to collect tens of millions of dollars in special payments from foreign companies to help them obtain valuable mineral rights. He wanted to move the money to the United States to buy a house, a jet, and a yacht.
So therefore he wants to bring in the money into the US. So starting with the brownstone and then probably buying Gulfstream jet. He wants to commission the building of a yacht and buy probably more property.
The story was intentionally devised to raise red flags and lead the lawyers to believe that the minister's money was dirty. During the meetings, only one of the 16 lawyers, Jeffrey Herman, told him no.
The same for me. My standards are higher.
The rest expressed varying degrees of interest, with most of them offering advice on how it could be done.
We do everything, soup to nuts. So there's no limitation. We don't say, oh, we don't do windows, or we don't deal with the financial and money manager, whatever. No, we orchestrate and organize the entire thing. We're happy to take that responsibility.
What's important to point out, and it cannot be overstated, is that none of the lawyers we've shown you broke any laws, in part because the African minister didn't really exist, there were no hundreds of millions of dollars, and Global Witnesses Sharmi and Gooch said no money ever changed hands.
So this is sort of a morality test.
It wasn't, it was a test on the system.
You know, people could make the argument, look, all these guys did really was just listen to this person that came into their office. They didn't make a deal, they didn't sign up, they said we need to do some more research.
And you know what? They'd be absolutely right to say that, but they need to say something else too, which is that those lawyers laid out in often considerable detail a myriad of different ways to bring money into America.
None of the lawyers agreed to take on the African minister as a client, nor were they asked to. It was a preliminary meeting that ended with most of the attorneys expressing interest in continuing the dialogue and some enthusiastic about landing the business.
Steve Croft joins us this morning. Good morning.
Morning, Nora.
Incredible piece to watch. So none of these lawyers technically broke any laws. How is that possible?
There was no crime. I mean, everything was fake. So no money changed hands. There was no minister. There were no millions of dollars. And, so there was nothing to prosecute.
Commissioner Bratton has a saying in New York, I've heard him say, it could look awful, but it's lawful. And when I was looking at that last night, I was sort of thinking that. But when you air the recordings, aren't those attorney-client privilege? How are we able to see that?
Well, it's strange. I didn't know this before we'd done this story, but the privilege really is there to protect the client, not to protect the lawyers. And the client, which in this case was Global Witness, they control the privilege. And if they said, we want to release the contents of this conversation with our lawyers, it's their right.
One of the lawyers was James Tuckanet, was it? And he's head of the Bar Association?
Was the head of the Bar Association at the time this happened, the American Bar Association. I think because he was head of the Bar Association and representing lawyers in the United States, I think that was the main reason. I mean, he was a little bit different category, and because he was specifically selected, and also he was much more suspicious of the African minister than some of the other people, and he was much more cautious in his party thinking about moving forward. They said that they didn't participate in anything in which any criminal activity was involved.
But only one lawyer, though, Mr. Herman, I thought he was great, where he said, this ain't for me, my standards are higher. Was that surprising to you?
Very surprising.
Yeah, but there was only one.
Only one.
Yeah.
I mean, all the other lawyers expressed some concern that they didn't want to get in trouble, that they knew that there were legal issues involved.
But then, Steve, they came up with ideas after they
Yes, and then they went on to give advice.
So what do you think the end result of this is? Do you think legislation will be proposed? There seems to be a gaping loophole.
Well, I think the Bar Association will probably step in and do something. I think that they need to tighten up some of their own regulations. They have a bit of a PR problem here, I think. The other thing is that there is legislation.
I'm going to stop it right now with the presentation. Okay. Perfect. So we have that issue in the Americas, but also here in the neighborhood, we have problems very close by in the UK. So, but before tackling the UK, do you know, guys, who knows what is the Financial Action Task Force? The Financial Action, please.
Well, I know it's there. It's an international task force, the Treasury Department in the U.S. I don't know, it must be Treasury in the U.K. too.
It produces a list of countries which are in fact on its wrong list.
Yeah, thank you. So the Financial Action Task Force is an international organization based on Paris, and it was created by the G7 under the OECD. It's an international body, and they cooperate with many countries in the world, including, of course, the US, the UK, Colombia, Mexico, Italy, India, and they set up international law. We call it soft law recommendations to fight against money laundering and terrorist financing. So they do like an examination of the countries to see the compliance of those countries with the FATF 40 recommendations, and recently they issue a report to assess the level of compliance of countries with the new rule from FATF about having lawyers as a gatekeepers for anti-money laundering purposes. Guess what? China, Australia, and the US score 0% in compliance. So for me, that doesn't mean that those countries are doing bad in terms of the fight against money laundering. Because at the end of the day, international law, countries can say, I take international law, or I do not take international law. There is no like a central power to enforce countries. You should, you must, you shall, otherwise you go to a global jail. That's not the case. But that is an indication, this is a report. So more or less within the same time frame, a couple of weeks ago, the US Treasury Department issued a statement that they are going to seek to make US lawyers part of the EML international legal framework. So we can expect in the US some rules coming out to have lawyers having compliance programs to comply with these FATF regulations. So, but it's not only in the Americas, also in the neighborhood here in Europe. We have some issues in the UK. So the Mishcon-Darea scandal, it was a scandal of law firms and money laundering. And let me show you the case. So there goes the neighborhood. Okay, perfect. So this law firm, London-based law firm, they provide services to two unknown individuals. They wanted to set up corporations and then sell the corporations incorporated in high-risk jurisdictions for money laundering. Secondly, so they use the attorney's client account as a banking facility to move money. So they put money in July 16, more or less 965,000 British pounds, and then a couple of days after, the money went out of the attorney client's account with the 810,000 British pounds in a very short period of time. That was a suspicious activity. And under UK law, attorneys in the UK cannot provide the client accounts to clients as a banking facility because it's a violation of professional responsibility rules. So, and there was no legal services involved to justify the money movement through this account. So the SRA, which is the Bar Association in the UK, the Solicitors Regulation Authority, they prosecute, investigate, and they find this firm, this law firm in the UK. Lawyers, we got a problem. Houston, we got a problem. Lawyers, we got a problem, right? So does international law care about the issue? Yes, of course. International care about the issue. In particular, the Financial Action Task Force, they say that lawyers are gatekeepers under international law to stop criminal funds to go into the financial system for money laundering purposes. The cycle of money laundering is placement. You go to the bank and place the criminal money. Then you do transactions like layering, just to separate yourself from the criminal activity, and then you integrate the money into the formal economy. How? Purchasing companies, purchasing real estate, whatever is the case. So gatekeepers, attorneys, have the capability to say, no, I'm not going to offer this because this is a crime. So within the FATF recommendations, international law, we have the due diligence and the report suspicious activity. So it's very important that the attorney can do due diligence on his or her clientele, right? Who I am doing business with, who I'm going to represent at any litigation, right? Also, if the attorney can spot any suspicious activity under this international law regime, they have a duty to report the suspicious activity. But you can say, hold on, the attorney-client privilege. I have a duty, they have the privilege. I also have a duty of confidentiality regarding all communications between the attorney and the client. So also here in Europe, we have the EML Directive number 4, it's a European law, which makes European attorneys, makes them part of the EML programs in Europe. So they have to have here a compliance program to comply with EML rules and anti-financial crimes rules. So now we have the dogfight. We have the report suspicious activity. This is a law coming from international law, from FATF, but also we have the attorney-client privilege. So how in the world you reconcile those principles? Very difficult, right? We'll see. It's covered the attorney-client privilege is all communications between the client and the attorney made for the legal representation, to facilitate the communication between the client and the attorney for legal advice or for legal representation. That's very important. In the US, the federal courts have said that the attorney-client privilege is the most sacred privilege of all the privilege. It's the most sacred privilege because it helps the justice systems to work properly, right? But like in law, every single general rule has its own exceptions, right? And in this case, we have a very strong exception, which is the crime fraud exception. So when the attorney is being used by a criminal to commit fraud or money laundering, an ongoing money laundering scheme or fraud, in that case, the attorney doesn't have to keep his duties to the client, and in that case, the attorney can report the activity to the proper authorities. Well, we have good cases in the Americas. The Objon case is a very wonderful case. I love it. So we're going to just talk about very briefly in 2 minutes about the case. So Objon Company was a pharmaceutical company operated in the US. They, at the moment of the case, corporate officers of the Objon Company offered corrupt payments to foreign officials of governments to secure business with foreign governments. So when the board of directors learned about this corrupt activity within the company, they ordered the general counsel of the corporation to initiate an investigation to see the scope of the issue. So general corporate counsel started to do some questionnaire and some surveys within the corporation. And after this investigation, it was found that indeed Objon Company was involved in making bribes to foreign officials to get business with foreign governments. So when that happened, the board of directors decided to disclose the information to the U.S. Securities and Exchange Commission because this company was a public traded company, so they had to report, financial statements, whatever, to the U.S. Securities and Exchange Commission, and they disclosed voluntarily this issue at the SEC. Oh, Mr. Regulator, we found this wrongdoing in the company. We fired all the corrupt, the bad apples. We fixed the issue. The SEC decides to transfer the case to the IRS, the International Revenue Service in the US. And guess what? The IRS initiates its own investigation, and the IRS subpoena the investigation, summons, issue a legal requirement at the corporation to disclose all of the attorney's conclusions, reports, investigations, answers of the company for the investigation purposes. Guess what? The corporate counsel said, no, I'm not going to disclose this information because this information is protected under the attorney-client privilege. And the IRS went to the federal court to battle this, and the case ended up going into the U.S. Supreme Court. And the ruling from the U.S. Supreme Court was that, yes, corporate counsel of the Objon Company is right. The IRS doesn't have any legal grounds to request this information because the attorney-client privilege. And in this context, the board of directors was the client for the attorney, and the attorney itself was the in-house lawyer. So in that case, there was a relationship between the client, the board of directors, and the attorney. And all the investigation that the attorney conducted was privileged under the attorney-client privilege. And you can say, hold on, but they commit a crime. Yes, they commit a crime, but it was a past crime, no ongoing crime. When it's an ongoing crime, you got deception, and we as an attorneys, we should report that activity when we know that the client is using me for criminal purposes. But when we're talking about past crime, we operate the privilege. Okay? So takeaways, lawyers, definitely we are gatekeepers on the customer international law. And why customer international law? Anyone remember what is customer international law?
It's what nations do, whether it's written or not.
Yes, state practice from governments plus opinio juris, like they sense like a legal obligation to follow the state practice. Here in Europe, pretty much all of the state members of the European Union have enacted national legislations to reflect the EML Directive number 4. Enacting legislation is a state practice. Statements from high officers of governments also is a state practice. The statement made by the U.S. Department of Treasury saying that they are thinking to make lawyers part of the regime is a state practice, in particular coming from a big country like the U.S. They have a great influence in international law. All of the countries in Latin America, in Asia, Australia, they have adopted the 40 ATF recommendations, making lawyers part of this regime. That's also a state practice. And the states, the countries right now, they have a sense of obligation that this is the law. Therefore, I am concluding that the duty to report suspicious activity under this exception to the attorney-client privilege is part of the international law, in particular, as you said, non-routine law, in particular, customary international law. So, attorneys, we have a duty. Attorneys, we got a problem, but now we have international law saying that, yes, Mr. Attorney, if you are being used by a criminal to commit a money laundering scheme or fraud, you have to report because it's a duty right now under international law. So we have to do the due diligence of the client, and eventually we need to report suspicious activity. Watch out, do the due diligence. That's my presentation. Open to questions, of course.